laws in California, et cetera. So my name's Andrea Musicant. I'm an attorney at Meyers Nave. I have been practicing in the area of employment law for over 20 years. So I have a lot of familiarity with the happenings in on the employer side in California. And I help with trainings, I help with hirings, terminations, severance agreements. I do a lot of litigation. And so today we're just going to talk to you a little bit about how you can protect your company because it can be hard in California and it's a tough place to be an employer. So, and then I'll let Trevor introduce himself.
Thank you, Andrea. Yeah, and it seems to change day by day, doesn't it, with new laws
Yeah.
and regulations? And it is a legal quagmire, and this stuff is scary. But hopefully, you'll be able to break it down for us, demystify some of this stuff. And we're going to be talking about AI and hiring practices later on as well. So, very much looking forward to this conversation here this afternoon. My name is Trevor Blair, founder and CEO of Blair Search Partners. We are a recruiting firm focusing on nonprofit organizations and public agencies. And so I would imagine a lot of the organizations watching today are in the nonprofit sector, but I know that everything we're going to talk about is equally applicable to almost every organization in every sector. Even though most of the examples we may be addressing have to do with nonprofit organizations, if you happen to not be part of a nonprofit organization, I have no doubt you'll get a lot of value out of today's seminar as well. So we work with organizations of all different sizes. We do a lot of work in health and human services, the arts, a lot of work for foundations, and organizations of all sizes, from our $1 billion plus foundation clients to our small startup 501c clients. Or these are some of the issues that we're seeing them all grapple with. So we're excited to dig into this stuff today with you, Andrea.
Yeah. Okay, great. So we'll get started. I will hit my slides. I think. Oh, there we go. You guys saw pictures of us. More pictures of us. Okay, so I have been in some presentations where I love that we throw in some poll questions. This is to keep you awake, so you can stay awake during the whole time. So we'll ask you some questions. You guys take a few minutes or a few seconds to respond. Let us know. It's important, this question about the size of your company, because some laws affect you and some don't. So it can be really helpful to identify where your company falls into. And as Trevor said, they handle both, all sizes, as does my firm. We handle not really small mom and pop, but we can. It's just, litigation can be expensive. So okay, so great. So okay, we have a good mix. We have a lot of people with 100 to 249 employees, probably the majority here. Next is the under 25, and then the third category is the 25 to 50. So this will be perfect. You guys really, I think, will benefit from the information that we share today. Okay, moving forward. All right. Okay, so first we're going to talk about some new laws. As most of you know, every year California has tremendous number of new laws. I'm not going to bore you with everyone that came out, even though some of them might affect you because they might be employment laws. But I'm going to highlight a few of them that I think really affect all employers. So, of course, the first one is minimum wage. Okay. It raised this year from 1650 to 1690 on January 1st. So I hope all of you have been in touch with your ADP or whoever it is you use and have implemented that for your hourly employees. It's very crucial. Wage and hour claims in California are a very hot market for plaintiffs' attorneys. Certain industries, fast food establishments did not have an increase in 2026, but they're at $20 an hour. The healthcare industry also has specific requirements for theirs. And then there's a threshold for exempt employees. So if you fall under the professional, executive, or administrative exemption, of course, you have to meet a threshold salary. That went from 68,640 to $70,304 this year, or that's $1,352 a week. So in order to fall under that exemption, your employee must both meet the criteria and the salary threshold. And I want to just stop for a minute here because I want you all to know this is a really sticky area. And many of you already know this, but people get classified wrong all the time in California. Employers think that, oh, they're making executive decisions, therefore they're going to fall under the executive exemption or administrative exemption. I was going to give you an example. I had a client, this is not in the nonprofit, but it was a fast food company. And they had classified all of their managers at each store as exempt because, right, they make decisions, they decide who's working when and such. And it was a wrong classification. So that can be a really, really painful experience to go through for a company. And you can look to attorneys to help you with that evaluation. And then also if you have to change the designation of people. So really something very important that I want all employers to pay attention to in California. There's also the computer professional exemption in California. That minimum wage minimum salary went up to 122,573 and 13 as of January 1st. Then in our wonderful California, we have some specific things that happen for people. San Diego has its own lovely wage an hour at $17.75. If you're lucky to live in San Francisco, it's at $19.18. So you really need to pay attention where your employees are located because it can really affect what you're required to pay them. And so it can get very tricky. One thing I wanted to ask, and you guys, if you want to put your answer in the chat, how many people know what the federal minimum wage is? If you can write that in. It's just curious if we had people. So the reason I ask is because the federal minimum wage is $7.25. So if you think it's hard to be an employer in California, you are right. It is a very different place to work than some other states. So I just thought that I would point that out. All right, moving on from minimum wage. Another new law that came into effect this year is AB 692. This is an important law because it changed that you can no longer have repayment requirements in your employment contracts. So for those of you who maybe have hired people and said, okay, come work for us, we'll give you this kind of training, but you need to stay with us for 6 months or a year. And if you don't, you'll have to pay us back. Those are no longer permitted. And so it's really important to review those kinds of contracts that you might have because you can't, you can be subject to civil penalties with regard to that. All right, and the next law I want to talk about is really AI transparency law. And everybody knows AI is such a hot topic right now in California. Governor Newsom is really trying to present us at the forefront. We're the birthplace of this kind of technology. And so we're going to be starting to see a lot of laws regarding AI implementation. This particular law really goes to cover developers. They have to publish and annually update catastrophic risk. They must disclose risk summaries. They have mitigation standards, third-party evaluations. Developers have to disclose all of these things, report qualifying safety incidents to the state. The law also provides for internal whistleblower channels now and anti-retaliation protections for covered technical employees. While this is aimed at the developers, employers using these frontier models should expect enhanced vendor disclosures, and they need to evaluate those procurement security, make sure it's in alignment with their company. So this is a new area of law that will start to affect employers. Okay, got another poll question to keep you awake. How many of you have distributed your Workplace Know Your Rights Act notice? Give you a few minutes to answer that. All right. Oh, you guys are amazing. Of 78% have distributed it. We have 11% as no's. All of you will go and do this after this meeting, I'm sure. And
And is that the big long
11%
tube
have
that
no
arrives
idea
at
what we're talking
everybody's
about.
office?
What's that?
Is that the big long tube here that arrived by mail in everyone's office a couple weeks ago?
It could be it might be just a
That big
one-page
roll
document, but there's definitely like you got to put up a big flyer in the
out?
office that everybody needs to put up every year. But this is a new one.
We
Lucky
just
us,
got
again
ours.
in California, we got another new law. So this one is SB 294, and it's a new standalone notice that has to be provided to every single employee upon hire and then yearly. It's provides information about workers' compensation and notice requirements related to conducting inspections by immigration agency. So this is a really obviously timely law right now. We have the labor commissioner posted a template on their website, and I think we have you can scan on our little slideshow there, so that you can see the template notice. This should be distributed to every employee. You send it out to them. We're required to, like I said, provide this upon hire and then annually. So to those employees that are already on your books, you want to send this out to them once a year. Failure to comply with this is a $500 fine per employee. So it's no small thing. Then additionally, on March 30th of this year, employers must provide employees an opportunity to designate an emergency contact. And the employer you must inform the emergency contact if the employee is arrested or detained on site. And a failure to comply with this will result in a $500 per employee fine per day that the violation is occurring, up to a maximum of $10,000 per employee. So, given everything that's happening right now in the United States, I think it's really key that all of you who had the no change that to a yes. I'm really glad that so many of you did distribute this. It was implemented. You have to do it by February 1st. So, get that notice out. You have a few days. Okay, so great. Moving on. All right, another new law that came into effect is AB 250. This law was created as a 2-year revival window for some adult survivors of sexual abuse and sexual assault to be able to file lawsuits that had been previously time barred. The window runs through December 31st, 2027. It applies to plaintiffs who were sexually assaulted on or after their 18th birthday, but had been time barred to bring their claims before January 1st, 2026. This is also if they had alleged that there was a cover-up. The plaintiff in these instances must allege that the entity or entities, including officers, directors, employees, or agents engaged in a cover-up. And a cover-up would be a concerted effort to hide evidence regarding the sexual assault or to prevent information from being disclosed to the public or to the plaintiff. The law does not apply to public entities. So if you're a public entity, that's not applying to you, but it also does revive claims related to wrongful termination and sexual harassment that have arisen out of the sexual assault. So this can very much affect employers if you have employees who maybe had been subject to something like that. Okay. Next law that I'm going to talk about is a paid family leave, SB 590. This beginning on July 1st, 2028, so some time, California is going to expand its paid family leave and include leave to care for include coverage for designated persons. The change allows employees to receive paid family leave benefits when they take time off to care for someone who's related by blood or whose association with that employee is equivalent to a family relationship. The employee must identify the designation at the beginning of the request for benefits and confirm the nature of the relationship. So while CFRA allows employees to take leave for a designated person, this update is allowing paid family leave to ensure employees can receive wage replacement during this time as well. So California, like I said, difficult place to be an employer, but a very good place to be an employee, and takes care of their employees as best they can. So it's another one in that factor. Okay. Another law that came into effect, and like I said, these aren't even all of them. So that's why it's so fun. Okay, so SB 464 is another law that was passed. There's penalties for failure with regard to pay data reporting. This amped up California's pay data requirements. Companies with 100 employees or more. So we got a lot of you on here today. You are already required to submit annual pay data reports containing demographic and pay information. But now, instead of organizing that under the 10 available EEO-1 categories, you must categorize the roles according to 23 different categories. And additionally, employers are required to store that demographic information separately from employees' personnel files. And the amended law requires that the court can impose monetary penalties for noncompliance. I've had some cases where Discovery, they request this information, and we've had big fights over this because we've tried to argue from the employer side that it's private confidential information, et cetera, but it is something that you are supposed to report to the government. Okay. All right. Okay, so we're gonna stop for a minute. Want to know if there are any questions currently on those laws. Like I said, I just picked out a few because I didn't want to inundate you all with the many, many laws that come into effect every January. But I thought these were important ones that could really impact you all, and something you could take back and make sure you have either implemented or know about. So I don't know, Tiffany, help me.
Andrea, I had a question while those other ones are coming in. Maybe if we could go back to the exempt threshold of 70K. If a employee is making above the 70,320 or whatever it is that after that, no other criteria matter? They can be considered exempt, or are there other factors that are considered in addition to the pay level? I'm going back to the example you mentioned about the restaurant, with the level of discretion they have in executing their duties and autonomy level of decision making and whatnot. So I guess my question is, if an organization is paying a 70,320 and above, are they clear and they can just call the role exempt, or are there other factors that also need to be met before the role can be called exempt?
Yeah, so absolutely, there are other factors. Unfortunately, that's just one of the factors. So that's like an easy one that people can tap into and say, okay, yes, I do pay the minimum threshold, but in order to classify under any of the exemptions, executive, professional, admin, or computer professional, there's different criteria that they have to meet. And it can be a very detailed assessment. On the administrative level, it's, how many people do they supervise? What kind of discretion do they have? So it really is an assessment that needs to be made. You can't just say, okay, I'm paying this person $90,000. They must be exempt. And I've given, and then you can't even do it just by title. So you can't just say, oh, they're the manager of, HR, and they make $80,000, therefore they're exempt. You really have to do an assessment about what it is their job entails and the different factors involved in that. And it can be really important, and it can be a really easy area for plaintiffs' attorneys to come in and attack an employer on.
Wow. I'm going to ask a follow-up question because I know a lot of nonprofit organizations have prospect researchers, data specialists. Can you tell us briefly a little bit more about that computer professional classification? Why
Yeah.
was that carved out? Why is it so much higher? And what type of roles would a prospect researcher who's using Donor Perfect or other databases, would they be in any way fall under that, or are we okay?
It's hard for me to make, I wouldn't guess, to say that someone is without looking at the job description, the job title. It's very specific. I think that it was probably carved out because California has so many, computer professionals, and the whole industry is separate. It does have a much higher wage and hour threshold, obviously, not sorry, a salary threshold. But there are criteria too that you have to fall under. So not everybody can just be classified because they, have sort of an analyst title again, and they're $122,000 a year. It's really important. It's really important for employers to assess what the job description is. And then that's not the only factor, because a lot of people think, oh, my job description says X, Y, and Z. And then a lawsuit will come in because the actual performance of the job doesn't include those things, right? You may give them a title and you may say, oh, I hired you to be, the senior executive analyst of this computer program, but the person does nothing like that, right? Their actual work is not involving executive functions, those kinds of things. So unfortunately, I can't tell you, oh, yes, that person is exempt. I have to look at the particular person to make that assessment.
Okay, thank you.
Great. Okay. Let's see. Okay, so we're gonna go into now hiring and recruitment practices that create California liability, again for California. I'm gonna let Trevor give a little introduction here. He's gonna maybe share some stories with us for hiring in the nonprofit sector, because he handles that all the time.
Yes, indeed. I'm very excited to touch on this topic here because it's still very much, I feel anyway, Andrea, the wild, wild west of AI and hiring and recruiting at all different levels for entry-level positions all the way up through CEOs. There's a myriad of different ways that AI is being infused into the hiring process. And it's interesting because we're kind of seeing this arms race between candidates adopting more and more AI as they are applying for roles and presenting themselves for positions. And of course, organizations are adopting AI to try and identify efficiencies and streamline the recruiting process. And in theory, maybe lead to better hiring outcomes. We have a lot of concerns with both of those. And again, it seems to be that, every time one side makes an advance, a tool comes out on the candidate side to meet that. And then the tool will come out on the candidate side and the employer AI applications will get slightly better. So we're just seeing this ratcheting up. The big question in my mind is, how do we get past that? Because ultimately the decision to hire a person is a human to human transaction, right? I mean, you are entering into a relationship as now coworkers and colleagues and as employees of an organization. And there are so many different AI tools out there that will do your resume. They will obviously write your cover letter. On the employer side, there are AI tools that will write your posting for you, that will field the applicants, that will screen the applicants, and that's a whole legal quagmire that I'm sure you're gonna touch on in a second here, Andrea. But at the end of the day, the only way to be sure that you are getting from the candidate side, you're getting the real organization, not the phony AI version of the organization, because you're buying that culture, that organization, just as much as they're buying you as an employee, right? And so, how do I know if I'm getting what I think I'm paying for, right? And on the organization side, how do they know that this employee really is who they have portrayed themselves to be, even though they've been using maybe all these AI tools in the background while they're going through the application process? We have seen, this is scary stuff. We have seen candidates using AI. Obviously, we just assume every cover letter and every resume has been put through multiple AI tools, and that just goes, without saying these days. But on the interviewing side, we have seen candidates using AI as they are real time in interviews, having multiple screens going where they can have an AI tool that will field the question as it comes in from the interviewer, process it, and spit out a response, and then the applicant can read it. One of our team members had this happen recently, and what gave it away was the micro pause, which is a little tough because there's always a micro pause on Teams and Zoom anyway, right? But the micro pause seemed a little bit longer, and their eye contact was not spot on. They tended to keep going up and to the right. And I can't remember how they got them to confess, but they essentially had a clip-on second screen on their monitor that was running AI, and they were just regurgitating what AI told them to say in response to each interview question.
Wow.
I was giving a presentation a couple weeks ago, and a hiring manager from a major healthcare organization said that the other day they had to stop an interview because it became clear that it was not an actual person, that the candidate was using synthesia to pretend to be an applicant and give the interview.
Oh my gosh.
So, if AI is getting that good, and they were deep into this interview, it was not obvious off the bat. If AI is getting so good on both sides, again, the only way to be sure you are talking to who you think you're talking to might be we have to go back to the old school face-to-face interview format.
Right.
Or maybe we have to go back to sort of impromptu, unscripted phone screening, right? Where it's actually, you give the candidate a window versus having a set time where they might be able to dial in AI tools and have them at the ready.
Hmm.
If you catch the candidate at some point that afternoon, the likelihood that they're going to, be sitting there with all their AI tools is obviously lower. So, I don't have any answers for any of these issues, but these are happening. And at some point, it's going to come to a head, and we're going to have to figure this out as, I'll call it, as recruiting and HR as a practice. So looking forward to jumping into your slides here.
Yeah. It is actually really scary. And I mean, if you have a huge applicant pool, right, it's not logical generally for you to have all of those people come in. You want to do some kind of filtering.
Yep.
It's only going to make sense for your, manpower to be able to do that. Otherwise, you're going to be hiring a lot of people to do hiring, and then you're going to have to let all those people go because you won't, need those people. So yeah, it's a really tricky area. I like your idea of not giving them a real time frame. Like we'll call you maybe between, it's like the people who come to fix your appliance, right? I'll give you a window between 10 and 12, and
Yeah.
maybe I'll be there at, 12:52. So yeah, I think is really a interesting factor for people to factor in. And then on the employer side, we have a lot of things that we have to pay attention to because we have to be really careful. We have so many laws that we have to comply with in hiring people, but we also do want to streamline things. So that's what this area is discussing for us for the employer. Okay, we got another poll question to get us started. Does your organization have an employee handbook, and do new hires sign an acknowledgement when you hire them? This is a really interesting question, especially because we have a lot of large employers. So I'll be curious to see the answers on this. I would think that more large employers do have handbooks. And someone asked me yesterday, so tell me why you need a handbook, right? Well, handbook's going to really provide you with a tool. People use it. Some people have told me when I'm helped them do, oh, look at that. Do you know that we have 100%? We have 100% on both categories. It looks to me like there are no no's. That's amazing. That's amazing to me, and wonderful, by the way. I think that handbooks are really, really key. They can also be a little tricky, right? Someone can easily say, hey, you didn't follow this, this, and this. And that's one of the things that when I work with smaller employers, I'll talk to them about not having one of those really robust handbooks, because you don't need to have every single policy written down. Because if you don't comply with it, then the person's going to come back and say, you didn't follow this policy that's in your handbook. Especially that can come into play with regard to discipline. So anyway, but that's wonderful. I'm glad to hear that. And there'll be another question that I'm even more interested to hear about if everybody has. So that's great that all of you who are on here already, 10 steps ahead of the employers that I'm helping who are getting sued. Um, okay, so all right. California does not actually have a comprehensive AI hiring legislation, unlike New York City, which does, but it's likely coming. And there are still significant legal risks with using AI tools. One of the biggest things with AI screening tools, with resume parsers and automated interview platforms, is related to bias, right? How do you make sure that you're not having bias within those AI tools? The EEOC and the California Civil Rights Division are really scrutinizing the tools that are coming out. There can be huge FIHA liability. The employer remains liable if the outcome when using a third-party vendor is discriminatory. So you can't say, we didn't know the algorithm was biased. Some practical issues with this is that algorithms can be trained on historical data that may actually replicate past discrimination, right? Video interview AI analyzing, if it analyzes facial expressions or voice, can actually disadvantage a disabled applicant. You wouldn't necessarily be aware of that because you didn't create the program. Keyword screening can exclude qualified candidates who don't use that jargon. So best practices are to validate the tools for adverse impact, really look at what you're using, maintain human oversight. You know, as Trevor mentioned, it's human to human contact. We don't want to lose that, and it's really important. Document vendor due diligence. Make sure that those that you are using have done some great due diligence, and ensure that accommodation options exist for applicants who can't use automated systems. This can be really, really important in this field. So be careful. I think they're great tools. I think AI is wonderful, but you really can't just give everything over. You know, you can't just try to save yourself money by giving everything over when you could really subject your company to significant liability.
And the other thing I'll add to that, Andrea, is that you also don't want to just give up your brand as an employer to AI, right? Because when you look at your brand, it starts not from when an employee joins your organization. The relationship and the employee experience with your brand, it's a long arc, and that arc starts with the first time they see your posting or the first time they come in contact with your brand. That's where the employee experience actually starts, and it continues all the way through hiring and onboarding and the exit interview, right? But the problem with leaning too much on AI is that, again, taking the human out of the process, and it becomes a very dry, very impersonal experience from the applicant's standpoint, right? And there's some formula that you have a bad experience, you tell 11 people, you have good experience, you only tell 3 people, right? You don't want to have AI running your hiring process for you and delivering a very synthetic, dry, robotic experience to applicants, because it will damage your brand in the employee marketplace, if you will, right? And I have never talked to a candidate, and I've talked to a lot of candidates who have been through AI-based hiring processes, and the organizations disclose it and whatnot, and there's a range, right, from candidates who are asked to record an interview and then that gets sent in to candidates who are actually interviewed by a bot, things like that. And none of them have said, wow, that was a really great experience. I really felt seen as a human and, really considered for me and my values and who I am, right? Said no candidate ever from an AI-based experience. And so a lot of damage can be done to employer brands by leaning on these tools too much, because they make for a terrible applicant experience. And where we see organizations truly stand out is when they use human-centered design principles and base their entire hiring process, and they base that entire arc of the employee experience around human-centered design principles, which really comes down to, if I was the candidate, how would I want to be treated and what kind of experience would I want to have? If I was applying for my own role again, would I want to log on and sit there and be interviewed by a bot and then have to go through all these other digital hoops? No, that would make me feel terrible, just like a number and a big waste of my time, right? I want to have a human to human interaction with an organization that sees and values me and my time, because as a candidate and an applicant, I'm giving of a very precious resource, my time. And if an organization is going to ask for the right to use that time to put them through a screening process, it is incumbent upon them to make that process as pleasant as possible for that candidate. It just comes down to simple human respect in my mind. So I just want to share that about, the human-centered design principled approach to engineering your hiring process versus a strictly AI-based efficiency approach to structuring your hiring process. Radically different, and in my opinion, radically different outcomes.
Yeah, I would think, Trevor, that even goes into when you think about it, continuing on as an employee, right? You could turn things into your evaluations,
Yep.
could go into AI tools, make things very, I mean, so many people are working remotely now, right? So people think, okay, we can make things that aren't as personal, but if you want to have retention, everyone knows that you've got to show your employees that they're valued, right? You got to make them feel like they're making a difference. And so many employers are struggling with retention, right? And what I deal with a lot is, if, terminations, et cetera, you don't want that kind of thing to turn into AI. It can't, because there's just too many factors that have to be looked at from a person to person perspective. So I think that can be really helpful. All right, moving on. So this issue, Pay Equity Enforcement Act, we touched on this a little bit with some of the new laws that came out. California employers already were required to provide for pay scale information in job postings, but now that pay scale information must provide a good faith estimate of the salary that a prospective employee can expect at the time of hire, not some point down the road. So this can be really key. And, when you have your job listings out there, people just scan through it real quick, right? They want to see the numbers and such. It's really important to comply with this. California also has adopted a non-binary definition of sex that expands the law by preventing pay disparity between an employee and an employee of another sex, not as opposed to the opposite sex. The law also updates the definition of wages to include all forms of compensation. So that would be non-salary compensation, such as bonuses, expense reimbursement, allowances, accommodations, stock options, that kind of thing. As well, the statute of limitations has been expanded to 3 years from the date of the alleged violation. So an employee can recover for that entire time up to a maximum of 6 years. That employee. And the statute provides when the accrual of this cause of action happens to be one of 3 times: when an unlawful employment practice is adopted, when an individual becomes subject to an unlawful practice, or when the unlawful practice affects the employee. So, pay equity and pay transparency is a really important category that I'm sure all of you have been, subject to now as you list your job offers. Job postings just really have to be very clear now. Let's see if I can move my next slide. Social media background checks. These are a really interesting area. That involves, right, where one of your hiring people can look at a candidate's online presence. What they can do is they can look at their public online presence, right? So you can look at LinkedIn, Facebook, Instagram. You can do that to assess cultural fit or verify information, identify potential risks like hate speech or violence. Oftentimes people hire third parties to run these searches, which is very smart, but those third parties, you have to make sure that they're Fair Credit Act compliant. So you need to create, to run a social media background check, you really should have an established policy. All of you have your policy handbooks. You may or may not have this as one of your policies. You need to obtain consent. You need to ask the applicant before you do the searching. Focus on public information, only view publicly available profiles, posts, etc. And then you're going to identify red flags, right? Violence, bullying, harassment, illegal drug use. And like I said, you can use third-party services, FAMA, social intelligence, Eurocom. They can help avoid getting into protected categories like race and religion, disability. The point is to verify accuracy of the information. You confirm that the social media account really belongs to the applicant. And then you look for, like I said, the red flags, threats of violence, hate speech, explicit or obscene content. You need to be careful if you are using third-party vendors, though, because, like I said, the Fair Credit Reporting Act is very detailed area of law, and you need to make sure that the third-party vendor is compliant with that. You want to be real careful about avoiding information you find on social media to make decisions. Let's just be real honest. If you do a social media search and you see that someone is very pregnant in your social media search, you cannot use that information in making your employment decisions. I know this seems very straightforward. Duh, I would never do that, Andrea. I'm not going to do that. However, it may come in without you even realizing as a bias. So it's really great to use these to help identify, potential threats, bullying, like I said, violence, hate speech, those kinds of things. Try and see if the person is a fit, but just make sure that when you're looking at those categories that they do not cross over into discriminatory areas. Okay. Another issue that's a big deal for employers now is the ban the box. That's California's law. It's officially the Fair Chance Act. It prevents most employers. So if you have 5 or more employees, you cannot ask about criminal history until a conditional job offer is given. It's the purpose, right, is aimed to give those who have a record a fair chance, removing barriers to employment and reducing recidivism. It requires individual assessments before rescinding offers. So for me, an example of this is I had a client who was in the retail industry and they did background checks, and then you have flags of theft, right? But you have to really investigate and give that person individualized assessment if the background check reveals a conviction. The employer must assess the nature and gravity of the offense, the time passed, right? Did this happen 20 years ago? Did it happen when the person was 18 years old and then they went on and had a good career? But, can you hold that against them? And the nature of the job sought, right? Some jobs involving young people or finance jobs, some of them it's easier to use convictions for that. But this applies to all private employers with 5 or more employees, like I said, and all public employers. So state agencies, cities, counties. There you go. Let's see. So I don't know if I have any, I have clients who are in the community college world. In the community college world, you also have to pay attention to the education code, right? Because that can come into effect, preventing certain offenses if you're going to have contact with students in that area. All right, we've got, did we have another question there? Okay, here's the one that I told you that I'm really curious about for you all. Does your organization have an arbitration agreement? And I will tell you that if you don't, I strongly recommend that you consider one. There's, pros and cons, obviously, on each side, but for those of you who pay attention to some of the verdicts that come out in California, there was a recent one of $100 million for an age discrimination case. These can be very, very significant verdicts because we really can't control a jury, right? So an arbitration takes it out of the jury's hands and puts it into an arbitrator. It can seem expensive on the front end. So interesting. We have 63% that say no and 38% that say yes. So I want you all to consider this as you go back and do your jobs over the next few weeks, whether an arbitration agreement really would fit with you in your industry, in your business. Because, like I said, in my firm, we highly recommend them. We have saved clients, you know, millions of dollars, if you will, but certainly hundreds of thousands of dollars by being able to come out and say, there's this an enforceable arbitration agreement, and we're going to arbitration. You know, straight up, we're not going to go in front of a jury that may get, you know, their passions inflamed and be able to say, oh yeah, I totally feel sorry for this little person. Of course, they were discriminated against based on age because, you know, whatever. But an arbitrator will look at it and say, really, did they meet the threshold of what you have to establish if the employer really did discriminate them against them based on age? So that's a really key factor. Trevor, do you have anything to say about arbitration? I don't know if you.
Well, I would have to imagine, Andrea, that going to arbitration is ultimately less expensive, less risky, and a whole lot faster than going to trial. And, you know, jury selection alone can take weeks and weeks, right?
Absolutely. I mean, it happens so much faster, right? Generally, what happens is you get a lawsuit, you immediately look and see, does the company have an arbitration agreement? And you hit the plaintiff's attorney by saying, hey, guess what? You have signed an arbitration agreement that's enforceable. We're going to arbitration. Takes the wind out of their sails right away. I mean, it's a huge just psychological impact. And then, you know, you select your arbitrator. It's like a trial. You know, so it's not the plaintiff really does get a fair opportunity to have themselves heard. It's basically almost like having a judge trial instead of a jury trial, but it's so favorable to the employer. It happens so much faster. You know, there's still high costs because there's motion work and all that kind of stuff that comes into play, but you don't have to go before the court every single minute of, you know, every step of the way. So to the extent that you can get those enforced, you know, now with PAGA, there's, you know, a huge, this is, most of you on this call, I'm sure, probably understand PAGA, and it's a Private Attorney General Act, and it's a really hot area of law for plaintiffs' attorneys. It's in contention in the courts a lot, but a lot of times employers are able to argue that the individual's claim has to go to arbitration first, which can be, again, very valuable and take the wind out of the sails of very expensive lawsuits. So, okay, so I know I have one question that I had from someone asked me if the SB 590 says 2028, if that's correct. And yes, that is correct. That's when it goes into effect on that one. Are there some more questions that people have? You get a chance to hammer an attorney. I hope that a few of you will take that time. Let's see, Tiffany, Tiffany's gonna bring me
I
up.
was going to make one more comment on AI and using it to screen, interview and screen candidates. And the other problem with, in addition to everything we talked about with, you know, delivering a high value versus low value experience for applicants and employees, the other problem is that AI is much less likely than a real life human being to be able to identify transferability of skills, right? And so the tool is trained on a series of data points. It looks for those data points. And if the candidate doesn't have those data points, it doesn't get screened through, right? Versus a human being who can see that, oh, this candidate hasn't actually held this job title before, but I can see where they've picked up highly relevant experience in these other areas. And so what happens is, you know, when you use a rigid AI tool, you tend to get the usual suspects in terms of the candidates that are coming through, right? And it is the outside the box candidates. It is also diverse candidates tend to be screened out too when you're using very rigid screening criteria. People who are trying to change industries, change sectors, change job tracks, those are the people who are going to suffer the most with a rigid AI-based screening process. And if you are looking for a really diverse, compelling, well-rounded workforce, you're probably going to have a much better chance of getting that by having a real live human being at every touch point of your hiring process. Now, that doesn't mean you can't use AI at all. By all means, use it to create your job description, use it to, um, take your notes and maybe synthesize your notes into candidate summaries that you can then attach to the resumes as you share them with colleagues and they're going through the process. There are a lot of time savers that AI can do for you in the hiring process, but I'd really caution you against using AI to do what is still fundamentally a human being's job.
I think you're so right, and I do think it really will impact that diverse candidates. I mean, there's no question, and you want to see people face to face, be able to assess them and their answers. And it's why we don't completely rely on written questions, et cetera. We always move to a personal interview eventually. And so hopefully those people aren't using
Yep.
that where they're turning off to the left, getting their answer
Yep.
from AI. That would be nutty. So let's talk a little bit about we're gonna focus a little bit more on the nonprofits and Trevor, maybe you can tell me a little bit of what you've seen with regard to wage and hour exposure on the nonprofit side. How subject to those kinds of lawsuits are that industry?
Yes, particularly and certain sectors have employees who are in frontline roles and at pay scales that are much more likely to be impacted by wage and hour type considerations, right? If you have, say, an architecture firm where everyone's, a professional making well over six figures, these issues aren't necessarily going to be that relevant. But if you're a large human services provider, and let's say you've got a lot of frontline programmatic staff who may be doing things like medical assistant type duties, counseling, running summer camps, right? Some of these are entry level roles, and a lot of them are paying right around that minimum threshold. And not only are the legal impacts real, but also the financial impacts for the organization, right? Because they've built their entire budget and model based on certain assumptions of how many roles at what wage and hour categorization do we have, and then what do we have to do to fundraise around that to have a balanced budget every year? Specifically, where we have seen this happen is there used to be some carve-outs, I believe, for organizations that were in the workforce development space and had folks who had very limited work capabilities. And so there used to be, and correct me if this has changed, Andrew, I'd love to hear your thoughts on this. Certain categories of individuals, if they only if they had certain limitations on what they could do at work, then there was flexibility in the pay scale to accommodate for their accommodations, right? So if someone was at 35% productivity, then they could be at 35% earnings, so to speak. And then I believe that got changed recently, whereby now the minimum is the minimum regardless. And so the employer either has to eat that productivity gap, right, between the value of what the person is capable of producing and the minimum wage, or eliminate the role altogether. And so a lot of organizations, I think, were having to rethink and pivot on how they were employing that category of people.
I haven't actually, I'm not familiar with there being a distinction where you can pay someone less based on their abilities. That's a kind of an accommodation issue that can come up very significantly with a lot of clients. And you have to assess, can they do the job? If they can't do the job, then the employer's not required to hire them or to keep them employed, right? Those are very key factors that employers have to assess all the time. When someone comes to them and said, but sort of a diminished capacity or that kind of a thing. I'm personally not familiar with, paying at a different scale with regard to that. But in general, what I say to all my clients is treat everybody the same. right? I mean, that's what we have to do. We want to be real, even in how we make our decisions, right? In our hiring, in our terminations, in our accommodations. I mean, accommodations is very specific to each person, right? If somebody has certain accommodations that they need, but you can't treat someone differently because obviously any category that they would fall into that's a protected category, you've got to treat them similarly. And same with the hiring and firing of people, that same kind of thing where you want to make sure that you're treating everybody the same. So I would say the same with regard to that issue. I'm not, aware of paying people differently based on any kind of capacity. So it's definitely talk to an attorney before you would do that kind of thing. So I got a question that someone said, how do you feel about giving rejected candidates feedback on their interview? I would recommend against that generally. I think that you can get yourself into difficult situations where what you say to the person, during the interview, the people remember, right? People remember negative feedback. So you don't want to necessarily, this is like with a termination too. I say, this isn't a great fit. I keep it very simple, provide the less information, the better. I know that might not go to Trevor's idea of like presenting who we are, right? As a human organization, but I just think that you need to protect yourself as an employer. And so as much as you'd like to give that person feedback, my recommendation would generally be not to. I think you're going to be much safer. I'm all about protecting the employer in these situations.
I have a question, Andrea, on the nonprofit side. Sometimes the line between a volunteer and paid staff can get blurry. Have you seen any instances where organizations have gotten themselves in trouble where someone who was working in the capacity of what the organization thought was a volunteer, and all of a sudden they get hit with a claim that no, I was actually doing the work of a paid employee and should be paid accordingly? Do organizations sign like volunteer agreement letters or anything with volunteers these days that say, I understand that no matter what, I am not going to be paid for what I do for this organization?
So there are definitely a lot of forms that volunteers fill out, right? Liability of all different sorts. I'm not sure that I, again, would recommend that one said, I absolutely, I'm not sure it would hold up if you had one that said, no matter what, I'm not going to get, paid for this kind of thing. But I think you can lay out what kind of activities they have, how much autonomy they have. How much do they get to say when they get to come and volunteer? What, they're doing? It's somewhat similar to some employees that, whether that goes into the exemption issue. But yeah, I wouldn't think that you could have something that flat out says, we will never pay you, right? Because I mean, I'm sure someone could come up with an argument of why I actually was an employee, but I think you can have very clear standards that say I'm a volunteer. This is what I agree to do. I won't violate any of your policies. I won't take any, you can have them sign things like I won't take any of your proprietary information. I'll keep anything secret that needs to be kept secret. And safety, and am I willing to use my picture, that kind of a thing. You can have all those kinds of forms. But I think that's a really interesting question. I haven't had a case like that where someone has come in and said, I'm an employee, I should get paid. It seems like a fascinating
Yeah.
argument. But I think you could, if as the employer, as I defending the employer, I would come out and say, I'd lay out all different reasons why they didn't fall into that, all the reasons that they had freedom to come and go, that they decided what they were willing to volunteer for, that kind of thing. Plus, I wouldn't have had anybody who's a volunteer probably sign a W-9 or fill out a W-9 if they're legal to work in the country, all those kinds of things. So there's a lot of factors that the person wouldn't, I would, as an employer, feel very strongly to say you are not an employee. Yeah. So I think we're at our hour.
Right on time.
Yeah. I appreciate everybody participating in the polls. I hope that it kept you a little bit awake. I believe we have a document with regard to many of the different laws that I touched on and other laws that I didn't touch on that my firm produces each year that we have available to the participants. I know that Trevor's available for any follow-up questions. I'm certainly available at any time that you want to reach out, ask me questions. Like I said, I handle all sorts of counseling issues and also on the litigation side, but counseling can be really important to employers who, need to ask questions about what they can and can't do in this crazy California world we live in.
Andrea, do you want to put up our contact info? I think we've got that somewhere in the deck,
Yeah, let's see.
so folks can reach
Oh,
out.
okay. I did have, I'm going to tell you, okay, I took away a couple, I guess the few key takeaways that you can take away on the hiring, on your hiring committees. Make sure you're current on the law. Pay attention to protected class expansion and accommodation issues. Document everything, right? Your selection criteria, your reasons for salary, the accommodation discussions, because people come back after you who are just applicants. And that's really hard on employers. And we're not even talking about people who you've already hired. So we have to pay real close attention to the hiring practices. Review your vendor contracts for background check companies, applicant tracking systems to ensure they're in compliance. The trend is clearly towards greater transparency, more applicant protections, just like it's in California, we protect the employees so much. We're also protecting applicants. So this is really important for people to pay attention to. Let's see, I'm getting to, here we go. I also have, I know some of you are getting MCLE credit or professional development credit. This is our slide on that, so you can get the information on that. We'll leave that up for a few minutes so you can get that. I did see another question about overtime deduction. Gonna ask that person maybe if you want to just send me a quick email because I'm not sure I know the question. But you definitely reach out to me and I'll be happy to answer that. And then I'll put up our contact info.
There we go. And I'll also add that our firm hosts a monthly career transition seminar for folks who are in the San Diego area. And so feel free to shoot me an email or reach out on LinkedIn. And if you're interested in participating in our February transition seminar, I'll be happy to send you an invitation. It's free and open to anyone who is looking for career guidance, whether you are looking for your next role in the nonprofit sector or as I mentioned earlier, any sector you may be looking to get into, the strategies and the tactics are largely similar. It's just applying them to different networks of people. So if you'd like to attend one of our upcoming career transition seminars, please reach out. We host them every month as well, and we'll be happy to see you there.
Okay, thanks everybody. Really appreciate you giving us your time today.
Okay, thanks everyone. Pleasure to be with you. Bye.
Bye-bye.